Well, welcome everybody to this second instalment of 39 Essex Chambers DIFC webinar series on banking and financial services disputes. For those attending in London, UAE and elsewhere, we're pleased to have over 100 acceptances, and today we focus on the recent DIFC Law No. 2 of 2025. This will be a round-screen panel discussion on a number of topics arising from DIFC Law No. 2 of 2025, in force from the 15th of March of this year. It's been over 20 years since the Judicial Authority Law, No. 12 of 2004, and the new law introduces important changes to consolidate and maintain the position of the DIFC as a respected and commercially reliable international financial centre. The law includes important statements of principle, and for example, the statement that the DIFC court shall exercise their duties and functions independently in accordance with the laws and existing DIFC laws and regulations. We will be speaking without slides, and we hope that you will find it informative and useful. We have the unique advantage of being able to call on the Chief Justice Wayne Martin as a member of 39 Essex Chambers to join us on this panel. James Scherf, one of our anticipated panel members, has been unavoidably detained by a current trial in the Commercial Court here in London and will not be joining us. In the usual way, there is a Q&A function. I'll endeavour to monitor that inbox during the webinar. In the unlikely event that we are able to reach all the questions, if the questioner wishes, we'll do our best to answer by email if he or she leaves their email addresses. We will keep to time and finish within the hour so that you can return or start your fee-earning days. A few panel introductions first. First, Chief Justice of the DIFC Courts, the Honourable Wayne Martin, ACKC. Before his appointment to that position and since 2019, Chief Justice Martin served as a judge in the DIFC Courts at first instance and in the Court of Appeal. In 2022, he was appointed Judge in charge of the Technology and Construction Division. Before his time at DIFC, he was, amongst other things, the Chief Justice of Western Australia from 2006 to 2018. I am Jonathan Bellamy. I'm a commercial barrister and chartered arbitrator based in London, practicing in both capacities in London and internationally in the Middle East and in Asia from our Chambers office in Singapore. I'm a licensed practitioner of the DIFC courts. My work in DIFC court matters has included sale of goods, banking, credit insurance, various arbitration-related matters, and interim relief. I will be discussing interim relief. Karishma Vora is a licensed practitioner at DIFC courts. She is admitted in India and in UK and is a member of 39 Essex Chambers. She's an experienced practitioner at DIFC courts. She will be speaking on contempt of court and mediation. Alex Burrell has extensive experience in DIFC disputes. He worked on secondment, in arbitration and on the DIFC team at a leading Dubai law firm for 2 years and has remained a DIFC law practitioner after returning to the UK and joining 39 Essex Chambers. He frequently appears in DIFC court matters. Alex will be discussing enforcement and the new provisions regarding constitution of the Court of Appeal. So, I will kick off by talking about interim remedies. This is dealt with in the new DIFC law by Article 15. It's a topic of general importance to all commercial and arbitration practitioners, but in particular relevance to banking disputes. It's an important legal jurisdiction given DIFC's increasing prominence in international banking and finance. In terms of scope, this topic should be considered in conjunction with the provisions on jurisdiction in Article 14. And I observe the width of Article 14b, which confirms jurisdiction in any civil and commercial claim where the parties agree either before or after the dispute arises. In terms of breach, it should be considered in conjunction with contempt proceedings under Article 35, on which Karishma Vora will speak, and in terms of aim and enforcement and purpose, the enforcement provisions of Article 29, on which Alex Burrell will speak later. As an overview, this provision should be seen as part of the consolidation of DIFC's 20 years and its maintenance and progression as an established financial offshore jurisdiction supported by the DIFC courts. The new provisions consolidate what recently become the established law by judicial decision and is evidence of the internationalism and comity with other offshore and onshore jurisdictions. It is also a reflection of the sheer volume of liquid funds now held in the Emirates of Dubai. An example is the recent decision in Neville and Nigel of 2024, in which was injuncted some 230 million US dollars in an onshore Dubai accounts. Article 15 is a clear example of what has been described as, and I quote from others, a flexible and progressive attitude to the development of the DIFC courts. It codifies the recent previous decision in Carmen Coenda, which itself reversed the Sandra Holdings decision. The paragraph in the Carmen Coenda judgment from paragraph 148 as to the function and purpose of the DIFC courts remains instructive in this area, where two practitioners, when considering how the court will approach issues relating to the development of the jurisdiction. In paragraph 155 of that judgment, it was said, and again I quote, the DIFC courts are part of a growing network of international commercial courts in a number of jurisdictions around the world, where their jurisdictions and powers are amenable to constructions supporting the rule of law in transnational trade and commerce. Such constructions should be preferred. That, in my view, is an important indication of the general approach in which the courts will take to such applications, and Chief Justice Wayne Martin may very well have views of a general nature to express on that in due course. Carmen Coenda, the decision itself, is now of principal interest to practitioners on the doctrine of precedent in the DIFC courts and the limited circumstances in which the Court of Appeal may choose to overturn a previous decision. And on that point, Alex Burrell will have some comments on the constitution of the court and the provisions which allow and permit a 5-judge court. Turning back more specifically to Article 15 for a few more moments, it's important to recognise that this is not just about freezing injunctions, nor just about worldwide freezing injunctions. It's also about disclosure orders and true identity orders. Article 15.2 is particularly important in relation to banks and cryptocurrency exchanges, a business which is developed in Dubai and DIFC. For true ID, UBO, ultimate beneficiary owners, and in fraud cases generally, these provisions are important. They encapsulate what in English law we have traditionally developed by judicial decision in Norwich Pharmacal and Bankers Trust order cases. The language of Article 15 on this point is important. It refers not only to defendants, but to potential defendants. and also to cases that may be brought in the jurisdiction of the DIFC courts. And again, it may be that Chief Justice Martin wishes to say something on that point too. The point that I would wish to emphasize here, given the new law that we've got and the consolidation that there has already been, is the likelihood that it will be interpreted in an expansive manner to support other respectable offshore jurisdictions and other onshore jurisdictions. Article 15.3 provides jurisdiction for orders within the jurisdiction of the courts itself, the DIFC courts itself. And perhaps most interestingly, Article 15.4 provides an extensive increase in the jurisdiction, in particular to future arbitral proceedings. The text of that order, I dare say, will be subject to some judicial consideration in the coming months and years. It is again widely drafted. It's worth you reading it carefully, and I commend it to you. It refers to applications, claims, or current or future arbitral proceedings. And it's tethered to the DIFC law so that the remedy, the interim remedy and relief proceeding is not limited by the jurisdiction of the proceedings or the arbitral proceedings, but is connected inevitably to the presence of assets in DIFC and possibly, I anticipate, via the conduit jurisdiction to onshore Dubai. It strikes me that this is a potential alternative route for parties who would otherwise have sought an emergency arbitrary appointment in other jurisdictions and sought proceedings in other jurisdictions on a worldwide basis to injunct and freeze assets that are believed to be within the jurisdiction of DIFC. And it would seem to me that it's preferable to go to the DIFC courts themselves under Article 15.4 in that situation. I've talked about expansive interpretation. I've talked about purpose and aim of the DIFC courts. From a practitioner's perspective, it is, however, always important to recognise that all the normal requirements of interim measures remain. There must be a good arguable case. There must be an immediate risk of dissipation of assets. And of course, your clients must be prepared to give a cross undertaking for damages, which is a critical point of any interim relief in any jurisdiction. So with those comments about interim remedies, I will, of course, take this opportunity to offer the floor to Chief Justice Martin, should he wish to add anything, before turning later to the following speakers.
Yes, well, thank you very much, Jonathan. I'm happy to make a few observations, and given the subject we're discussing, it's important that I start with a disclaimer, as lawyers normally do. The disclaimer is that I am expressing views in a personal capacity in a forum that isn't the exercise of judicial power, so nothing I say should be construed as indicating any predetermined view as to the proper construction of the provisions to which reference is being made. Obviously, such a view can only be formed and expressed after hearing appropriate argument in appropriate proceedings. The subject, just by way of general background, can I say that the new courts law was several years in the making, as one might have expected. And its general effect is to put in one place, and significantly in a law of Dubai, not a law of the DIFC, the provisions that were previously found in the Judicial Authority Law, number 12 of 2004, which was a law of Dubai, but also the former courts law, which was a DIFC law of number 10. So they're all now found in one place, which is a law of Dubai. And the significance of that, of course, is that it binds the entire Emirate of Dubai, so it binds the onshore courts. So they are obliged to respect and give effect to that provision. The saving provisions in Article 43 maintain any regulations issued under the previous laws to the extent that they're not inconsistent with this law, which of course has the effect of saving the rules of court made under the previous laws. So that's just by way of general background. In terms of Article 15, which, as Jonathan mentioned, is a significant article, its structure is interesting in the sense that its first three limbs essentially all relate to, or all tethered to, the jurisdiction of the courts, so that they all have some connection with claims that might fall within the jurisdiction of the DIFC courts, present or future. But the fourth limb, as Jonathan has mentioned, is different, and it has no connection to the jurisdiction of the DIFC courts. And we've read with the preamble, it provides the DIFC courts have jurisdiction to hear and determine applications for interim or precautionary measures related to applications, claims, or current or future arbitral proceedings brought outside the DIFC, seeking suitable precautionary measures within the DIFC. Now, the ambit of that provision is the subject of proceedings before the Court of Appeal at the moment, and which is why I emphasise that nothing I say should be taken as expressing a concluded view on that subject. Those proceedings came about in the following way. A worldwide freezing order was issued in the English Commercial Court against various parties, including two defendants, a husband and wife who reside in Dubai, onshore Dubai, and who have quite substantial assets in onshore Dubai. Application was made ex parte to the DIFC court for a further freezing order applicable throughout the UAE. That application came before a single judge, ex parte, as I mentioned, who refused the application on the ground that he considered that the court didn't have jurisdiction because of his view that the court law had changed the position that applied at the time Carmen was decided. Court of Appeal sat a week later to consider that decision on an ex parte basis and reversed it on the basis that the Court of Appeal was satisfied that there was a sufficiently arguable case with respect to jurisdiction to justify the grant of the UAE freezing order. Now, of course, because it was ex parte, it would have been entirely inappropriate for the Court of Appeal to go any further. And after service, the Court of Appeal made directions which enabled a process to be followed so that after service upon the defendants, they could then participate in the appeal and ventilate their contentions with any contentions they wish with respect to jurisdiction. That is happening. The defendants have been served and have indicated that they do propose to contest jurisdiction, and we're trying to get that appeal heard as quickly as possible, hopefully next month. And so that will raise the question of whether Article 15.4, and indeed there are other provisions of the law that are relevant also, but the question will be whether Article 15.4 does, as might be seen to do, effectively reinforce the decision in Carmen, or whether the reference to the seeking of suitable precautionary measures within the DIFC somehow requires a connection with, for example, assets within the DIFC. Now, of course, there are many cases in the DIFC courts where it's been held that the presence of assets within the DIFC is not a precondition to the exercise of jurisdiction. So the question will be whether the wording in this clause has changed that approach. As I say, hopefully that'll be decided within the next little while. The other couple of points I'd make, Jonathan, to follow up, and I won't take too much longer, is you're right, there is a connection between the decision in Carmen and the introduction in Article 17 of the capacity to sit a Court of Appeal of 5 members. That provision was introduced at my request so that if the situation in Carmen did repeat itself, I would ordinarily direct that a Court of 5 sit to reconsider, to consider whether the court should depart from an earlier decision of the Court of Appeal. In relation to enforcement, I agree entirely with you that Article 15.4, whatever view is taken, provides a very convenient avenue for obtaining interim relief in relation to arbitral proceedings. And it's to be remembered that DIFC judgments can be readily enforced not only, of course, in the DIFC, but also within Dubai through the conduit jurisdiction, and we'll be talking more about enforcement later. But also, once the judgment is registered in Dubai, it's readily enforceable throughout the other emirates of the UAE, and also, of course, throughout the Gulf Convention, or the Gulf Council states, and through, and indeed most of the Arab League states through the Riyadh Convention. So if your dispute is centred in the Middle East and you want enforcement, a very good place to seek your interim measures is the DIFC courts, because you'll then have enforceability basically throughout the region. So there's just the observations I wanted to make. So thanks, Jonathan.
No, Chief, thank you very much. And a fascinating reminder about the scope and reach, if you like, of DIFC court judgments in the GCC. It's a point which I know the practitioners who are listening to this webinar will find very useful reminder. Karishma, can I turn to you, please, to address, you're going to speak on contempt, and I think also some words on mediation and reference to mediation centre in the new law.
Yes, thank you, Jonathan. Good afternoon to my friends and colleagues in Dubai, and good morning to those in London. As Jonathan suggested, two topics today, contempt and mediation. Both are new additions in DIFC Law No. 2 that we are discussing today. Starting with contempt, of course, this is a commercial law webinar, and we therefore did consider whether or not to include contempt. Contempt has acquired a reputation, associated with arrests, and it has a kind of criminal flavor to it. Contempt of court, however, finds itself in big bold letters on the front page of civil orders that many of you who are attending today, both in the English Commercial Court and the DIFC Court orders. There is a slight difference between the two orders, namely that in England, the words include arrest and imprisonment, and in the DIFC court, it does not, and I will discuss that in due course. In the end, we of course decided to include contempt in this webinar for the reasons that have been discussed by Jonathan and Chief Justice Wayne Martin. If the court has expanded its powers and under Article 15 has codified the fact that it will grant wide-ranging power orders, it ought to be able to enforce them. If the court is in support of foreign, or makes orders in support of foreign litigation or arbitration that does not have any apparent connection to the DIFC, well, can it make orders for contempt of court if those orders have not been followed? Let's take a case in example. Let's say you had a client that was successful in obtaining a judgment in a foreign jurisdiction. You might advise your client to apply for an interim supporting order, such as a freezing injunction before the DIFC court, and your client might be granted it by the DIFC court. Now, those with a freezing injunction practice will know that there are tight timelines following such an order, 48-hour and 72-hour timelines. And let us say that the other side does not comply by filing its affidavit of assets within those timelines. What advice would you give your client? There are two things primarily that can be granted by the DIFC court. The first is an imposition of a fine. But what if the naughty party has no assets within the DIFC? This is where there is a slight mismatch, because the DIFC court's jurisdiction does not extend to criminal justice. It is unable to make orders of arrest, and subject to Justice Wayne Martin's views, it's believed that it is unlikely to be granted a criminal jurisdiction due to strong policy reasons against giving it the power to imprison individuals. So in that circumstance, the court, the DIFC court, can refer the matter to the Attorney General. Now you might ask, is that effective? Just a reference to the Attorney General. And what will the Attorney General do? How swiftly will they act? In a case in 2020, which is also Justice Wayne Martin's case, called Latif and Leila, the DIFC courts had granted a worldwide freezing injunction and an asset disclosure order to aid enforcement of a New York arbitral award. The breach of the DIFC orders, so not a breach of the New York orders, the breach of the DIFC orders led to a contempt application before the DIFC court, and the court found both individuals as well as a corporate defendant guilty of serious contempt. It referred the matter to the Attorney General of Dubai for prosecution, and it was held that where the court deems its available sanctions inadequate to appropriately reflect the significance of the contempt committed, it might refer the matter to the Attorney General for prosecution in local UAE courts. The DIFC court noted in that case that its contempt powers are regulatory or at the highest quasi-criminal. This seems to have been codified now in the recent law. And this codification, of course, has built on the existing common law of contempt set out in Justice Wayne Martin's judgment. It is a step forward, and in my experience thus far, the DIFC courts are imposing conditional penalties that remain in effect until the contempt is resolved within a specified time frame. I will discuss two further things on contempt. One is what are the ingredients, what constitutes contempt, and the second, how might one purge contempt. In terms of ingredients, there are two cases that explain what the ingredients are. One is a 2022 case and another is a more recent 2024 case. The 22 case is Gulf Wings and AK Trading. In that case, the DIFC court held that proving contempt for breaching a court order requires a person, firstly, knew the terms of the order, secondly, acted in breach of the order, and third, knew that the facts making it a breach were being undertaken by that individual. This mirrors the English law position where contempt must be proven to a criminal standard. In the more recent case, the 2024 case, Nadiq and Najam, the DIFC court held that a person accused of contempt has the right to cross-examine witnesses as part of their right to a fair hearing, even though this does not find mention in the new DIFC court rules. Moving on, in the context of pronouncement of interim judgments, it is important to know that there can be no contempt if the underlying order was later set aside. So in the famous case of Sandra Holdings, and most of you will be familiar with that case, although everyone seems to discuss Sandra Holdings in the context of freezing injunctions rather than in the context of contempt. In Sandra Holdings, the Court of Appeal held that there can be no contempt where the underlying order, in that case a worldwide freezing order, was ultimately found to be invalid. Therefore, a valid and enforceable order is a prerequisite for a contempt finding. And in Sandra Holdings, the court therefore dismissed the contempt allegations. Purging contempt. Now, for the cynics amongst us who might feel that the DIFC court perhaps lacks teeth, this case will change your mind. So in Gulf Wings, which is also something that I had discussed previously in relation to the ingredients of contempt, the court held that it could only be purged upon payment of the full, and this is important, the full outstanding amount, including the full interest. Now, this involved a freezing order in support of a debt claim. The underlying case involved an aircraft, and the order was breached when an aircraft was moved. The DIFC court found the corporate defendant and two directors guilty of contempt and referred the matter to the Dubai Attorney General. The contempt order stated it could be purged by either returning the aircraft, fully satisfying the claimant's debt and costs, or apologizing to court and paying fines. One defendant paid the full principal debt, but not the interest. And this prompted the court to discharge the contempt order. The defendant that paid the principal debt prompted the court to discharge the contempt order, and the Attorney General closed the case. The claimant, however, appealed, arguing that the contempt was not fully purged because interest and legal costs had remained unpaid. The Court of Appeal agreed and held that removal of the aircraft did not cover interest and legal costs. The contempt orders were reinstated because although the principal debt had been repaid, interest and legal costs had not. So the contempt orders were reinstated and a letter was sent to notify the Attorney General of the continued finding of contempt, requesting him to reopen the case. In a hilarious sidebar on purging contempt, and actually this is also relevant for the DIFC jurisdiction, in one of my cases before the English court, I received a call in panic from my solicitors at about 6 a.m. on the day following the virtual hearing. Karishma, have you seen your emails? It turned out that despite the regular disclaimer in virtual hearings before a court, that the recording will only be by the court and not by any private party, an email had been sent around from our client's email address to everybody, including the judge, that had a complete transcription of the hearing. Upon discussion with the client, it turned out that he had a software that basically transcribed anything that was in his diary, and he thought efficiently sent it around to all parties. We advised him to send a groveling letter of apology, which he did. And thankfully, the judge had a sense of humor and purged his contempt by asking, well, how accurate was the transcription? This is relevant because a number of the DIFC hearings are virtual, and it remains to be seen whether a recording inadvertent will be considered to be a contempt. I say this because the new law has set out specific provisions of what constitutes contempt. So it has attempted to clarify the ambit of what is contempt, but by doing so, I wonder if it leaves out what it doesn't state. So the list includes interruption of proceedings, submission of fraudulent evidence, insulting a judge or officer, including on social media. Another article of the new law has ruffled feathers amongst the legal community because Article 35A says it is contempt for willfully insulting a lawyer conducting business in the DIFC courts, either before or during proceedings. Now, given the adversarial nature of DIFC proceedings, concerns have been raised about this provision, and one would hope that this is revisited soon. In summary, the DIFC court law introduces a clearer framework defining specifically what constitutes contempt of court and builds on the previous decisions of the DIFC court. I will be short with mediation. Mediation has been discussed in the new Article 13 that mandates the establishment of a mediation center at the DIFC, and DIFC judges will be encouraged to allow mediation. This is slightly different from the English position where judges can order compulsory mediation. So an encouragement at the DIFC versus compulsory mediation that can be ordered in England. In the DIFC, the procedure and framework are to be determined. And when the mediation center will be set up and become operational remains to be announced. Notably, the center will be accessible to all, regardless of whether or not they have an active claim before the DIFC courts. The DIFC courts will offer a venue and oversee the mediation process, provided that all parties involved consent in writing to mediate the dispute before the center. This is similar to the DIFC court's current workload, which hears a significantly high proportion of matters where parties have simply opted in to the DIFC jurisdiction rather than having penciled it into their contracts. The significance of mediation being codified can be juxtaposed, as I have explained, with England, where in England, there was a decision of the Supreme Court called Churchill, and that said that judges can order mandatory mediation. This was codified quite recently in England, and although there is no such mandatory mediation in the DIFC, it can order two things. It can order a stay of the proceedings and encourage parties to go to mediation, or it can pronounce an ADR order. And there is a format for the ADR order that is within the DIFC rules, which says the case management conference will be restored to enable the court to facilitate agreement on a neutral individual. This is if the parties have been unable to agree a mediator of their choice. And if the mediation is not finally settled, the parties shall inform the court by letter, so in writing, why it has failed. So this is encouraging of mediation and definitely a step forward. What I find most interesting, and perhaps Chief Justice Wayne Martin can provide some input, is both countries, England and the DIFC, are building on their common law decisions. So they're codifying their common law decisions, which one might say is not necessary because both are common law jurisdictions and judicial precedents find value. But both countries have chosen to codify. In the case of England within mediation, and in the case of the DIFC, it's codified its decision in Carmen. So are we moving towards a kind of hybrid civil law and common law jurisdiction? But perhaps Chief Justice Wayne Martin can answer that question in due course.
Karishma, thank you very much indeed for that contribution on both contempt and on mediation. Chief Justice, you've been invited to say one or two things, and you'll say what you like. And I just wonder whether there's anything like some contempt before mediation.
Yes, I'll start with contempt. Firstly, in relation to Article 35 of the new courts law, I must say again, entirely, ex curia, I don't read that article as being prescriptive or exhaustive in the sense that I don't read it as defining exclusively those things that can constitute contempt. I think it provides examples of things that constitute contempt, but I don't think it limits the field, as it were. Karishma is certainly right in pointing out that we don't have any jurisdiction to impose imprisonment by reason of contempt, which as a former judge in a jurisdiction where you did have such a power is a little frustrating. But one can understand the policy. The court's never had that power, and one can understand the policy considerations that inform the view that there might be some reluctance to allow international judges to imprison UAE nationals. So I doubt that there's going to be any change in that circumstance anytime soon. But it does mean that the only way such a sanction can be imposed is if the court decides to refer the matter to the Attorney General. We don't get feedback on what the Attorney General does when such references are made, although I am aware of one case in which apparently a prosecution was brought. But I'm afraid I can't really comment on the efficacy of that as a remedy. But what we have done in recent times, as Karishma mentioned, is to try and improve the efficacy of the remedy that we do have, which is the imposition of a fine, by imposing it conditionally. So in other words, the fine is imposed on and will apply unless the contemnor purges their contempt within a specified period. And that's intended to encourage people to comply. Of course, even if they don't have assets within the DIFC, the presence of an outstanding fine would inhibit their capacity to travel to the UAE. So if they ever want to travel to the UAE, that does become a bit problematic. But it's also the case, as I understand the law, the common law, certainly as it applied in my former jurisdiction, even if the time for compliance has passed and the fine has been imposed, a contemnor who purges their contempt may apply to the court to review the penalty. And so if a person does, even if we say you must do something within 21 days and they don't, so the fine is imposed, if they did it a week later, the court would have jurisdiction to review the penalty in light of the purging of the contempt. In relation to the interesting issue that Karishma raised in relation to unauthorised transcription of court proceedings, of course, in an ex parte case, that would be very problematic because the purpose of ex parte is to maintain the confidentiality of the proceedings. But in most proceedings other than ex parte proceedings are, of course, live streamed on YouTube. So in those circumstances, it's difficult to see how anybody taking another recording could constitute any form of contempt given the transparency that the court itself adopts. So that's all I wanted to say on contempt. Moving over to mediation, the current situation is that in the Small Claims Tribunal, mediation, or a form of mediation, which is I would call mediation light, is effectively compulsory in the Small Claims Tribunal. Every case in the Small Claims Tribunal has a mediation session before the case can be heard. I construe the rules of the DIFC, the CFI, as effectively empowering the court to require the parties to go to mediation, but that's not a power that I'm aware of has ever been exercised against the wishes of the parties. And I don't think it's a power that would be exercised against the wishes of the parties in an international court, because, of course, very often parties and their lawyers reside in different jurisdictions all over the world. And so if you require them to go to mediation, you are imposing a significant, and an in-person mediation, which in my view is the only means likely to be effective, you're imposing a financial impost on those persons, which we'd be reluctant to do. So what we have, however, resolved as a court to do is to make greater use of mediation and greater exercise of the, if you like, the suggestion to the parties that they should consider mediation, because mediation isn't used as extensively as we think it should be in the DIFC. In relation to Article 13 and the new mediation centre, that's different again in the sense that that mediation centre will be available to people who are not litigants before the court. So anybody from anywhere in the world, certainly anywhere in Dubai, can come along to the mediation centre, pay the fee, and we will try and organise a mediation for them. So that's a stream that will be possibly quite separate to the mediation encouraged by the court. And one advantage of it is, in addition to facilitating the mediation, we're also going to offer a facility a la the Singapore Convention, whereby parties can, if they wish, register their agreement, their mediated agreement, as a judgment of the court, providing enforceability. So that we think will be a significant advantage. And again, we're very keen to stimulate mediation. In terms of Varishma's question about a hybrid common law and civil law, we are in a sense hybrid at the moment, because many of the cases that are heard by the DIFC court, which is a common law court using common law procedure, have substantive civil law, because if they have the substantive civil law of the UAE, it is the substantive civil law. So in a sense, we're hybrid already. But in terms of mediation practice, I think the mediation practice that we will see evolving will have a Middle Eastern flavour, but it will still be fundamentally a common law-based approach, I think. So that's what I wanted to say on those two interesting topics.
Chief Justice, thank you very much. And the point that you make about registration of mediation agreements is, I think, an important one from our experience in Singapore with the ARB Med ARB provisions, particularly operating in international environment. I can see that as being a really useful addition. Thank you. Alex, you're going to speak on enforcement, and if time permits, to allow a couple of questions at the end on composition of the court, although the Chief Justice indicated he may still want to say a couple of things about that anyway. So look forward to hearing from you on enforcement.
Thanks, Jonathan. So I'm going to be speaking to you about some of the points related to enforcement that have arisen from this law. So why would this be of interest to you? Well, as lawyers, especially counsel, can often see judgment as the be-all and end-all of litigation, and that's the win. But as I suppose many of you solicitors and others will be more aware, as enforcement is the critical objective. We've already heard to some extent today about enforcement of interim measures, and so there are some interesting effects potentially of some of the parts of this law in relation to interim measures, which are of particular importance in banking and finance disputes, freezing injunctions and anti-suit, etc. So what does this new law say about enforcement? In many ways, it's just a reclarification of previous provisions. So a lot doesn't change, actually, but there are some subtle and important changes, some of which have already been touched upon earlier during this webinar. There's no changes to the mechanisms of enforcement. These are largely still contained within the rules of the DIFC court at 45.3, so charge over property, attachment of assets, execution against assets, appointment of receiver, also the other usual provisions for committal for contempt and insolvency. That's all largely the same. There is provision at Article 24B of the new court law in relation to receivers and provisional liquidators, but the old rules also had provisions for those under Part 49 and 54. There are some changes in relation to the enforcement or the new categorization of the role of the enforcement judge. So the new DIFC court law sets out the position of the enforcement judge at Article 29 and sets out their jurisdiction at Article 31. Article 31.7, interestingly, referring to the interim measures point, sets out the jurisdiction of the enforcement judge in relation to interim or judgments which were, or writs of enforcement issued by entities outside of the DIFC courts, and provides that the enforcement judge has jurisdiction to deal with disputes in relation to those interim, precautionary and urgent enforcement issues, including, as I say, for writs outside the DIFC. The enforcement judge is similar to how it was phrased as the execution judge under the previous JAL. There are some subtle differences. Article 29C, there's now an express power for the enforcement judge to stay enforcement if the judgment debtor is impecunious. That wasn't contained within the previous DIFC court law or JAL, though there was a general power of stay. It'd be interesting to see how this might be relied upon in enforcement actions within the DIFC jurisdiction, where you have parties from all over the world, and you can often imagine that there'll be allegations that a debtor is impecunious when they can, if they don't hold assets within the UAE, and so it's difficult to verify that whether they have any assets. So it'd be interesting to see how that specific jurisdiction is exercised. Also, briefly, it's now codified that the decisions from the enforcement judge are to be dealt with by the Courts of Appeal, but that was previously the case, but now it's set out more clearly. Article 30 sets out provisions in relation to enforcement writs, and there are some minor changes here as well, which have already briefly been discussed. So this includes judgments from the DIFC court and ratified awards. That was previously the case as well, but now it also expressly includes signed settlements approved by the DIFC court's mediation centre and settlement agreements ratified by the DIFC courts. That aligns with the provision of the Singapore Convention on Mediation, and I think we've already heard some references to that, and that might have been the inspiration for those elements of the law. It's noted also that Article 30D also provides for mandatory enforcement of writs of the DIFC court within the Emirates, so within the DIFC court itself, and the Dubai courts, including by force if so required. So this comes on to the next topic, which is conduit jurisdiction. Again, we've briefly heard something on this already. Article 32 effectively affirms or reaffirms the role of the DIFC courts as a conduit jurisdiction. To explain, as I'm sure many of the listeners are very familiar, the DIFC courts is often used as what's called a conduit jurisdiction. So what's meant by this is that parties will sometimes prefer to use the DIFC court to ratify a foreign arbitral award or judgment, including in relation to interim awards, before then enforcing in onshore Dubai. Some of the factors for why parties may do this is because within onshore Dubai or the UAE, factors such as the broad right of appeal, the potential for merits-based reviews, and the limited adverse cost implications for a losing party on appeal can act as deterrents for judgment and award creditors. You can avoid most of those factors by enforcing in the DIFC courts, and so often it's preferred to as a mechanism to go to the DIFC courts for enforcement first before referring on. This has now been confirmed within the DIFC courts. The new law, Article 32B in particular, provides that the Dubai court enforcement judge cannot examine the merits of the case in relation to execution writs issued by the DIFC courts. That is the same as what was in Article 7.3 of the JAL, but that's just reaffirmed. One interesting new development in relation to enforcement as between the DIFC and Dubai courts, though, is Article 32C, which provides for a broader interface in relation to judgments or judgments which are sought to be enforced from the DIFC within the Dubai. So, for example, it requires that the Dubai court's enforcement judge carrying out enforcement will inform the DIFC court's enforcement judge of the actions taken in relation to the enforcement proceedings, transfer any funds that are received, And in the event that there are any legal reasons preventing enforcement of the writ, they're to inform the DIFC court's enforcement judge of that decision. So it's hoped that that will again grease the wheels of enforcement as between the DIFC courts and the Dubai courts, and perhaps assist with the role of the DIFC courts as a conduit jurisdiction. Another brief reminder of enforcement of DIFC court judgments outside of Dubai. So in relation to other Emirates, again, to clarify, the JAL, both the JAL and this new court's law are Dubai laws, so they're not broader UAE federal laws, but they do clarify, or at least the JAL clarifies mechanisms by which you can enforce DIFC court judgments. In particular, it was at 7.2 of the JAL introduced in 2011, that you can theoretically enforce directly the DIFC court judgments within other Emirates, but and there are various MOUs that have been entered into between some of those courts and the DIFC court directly, but it's still often preferred because of the ease by which it is to enforce within Dubai first. It's still often preferred to go to Dubai first before going to some of the other Emirates. Briefly, England and Wales, and this is quite old law now. There is a memorandum between the English Commercial Court and the DIFC courts in relation to the enforcement of money judgments. Now, that's not a law signed between states, so it's not legally binding, but it does provide assistance in relation to enforcement of judgments between the two, and again assists with acting as a conduit role for enforcement of English court judgments, English High Court judgments within the DIFC, and then potentially more broadly. We've also heard briefly about from Wayne has touched upon the GCC and the Riyadh Convention. Whilst we've heard a lot, or that it's quite common for the DIFC court to be used as a conduit jurisdiction for Dubai, it should also be recognised that it can be used as a conduit jurisdiction for the wider GCC, and that'll be of a lot of interest for parties litigating within the region, and for parties who hold assets within some of those GCC countries. In fact, theoretically, the DIFC court judgment, as the DIFC is a court of the UAE, a DIFC court judgment can be enforced directly within those countries without having to go to Dubai first. So it'd be interesting again to see whether, as there is a greater acceptance of that position of the DIFC courts as a court of the UAE, whether we'll see more direct enforcement of judgments, including ratifications of, for example, foreign awards or judgments within other parts of the GCC. Briefly, I'm also going to touch upon the new Court of Appeal constitution. I know Wayne's already helpfully clarified that this was, as perhaps was suspected by many, a useful addition following what was seen at the end of last year with Carmen, a three-bench court overturning another three-bench court, and Carmen overturning Sandra Holdings. One query that there might be for Chief Justice Martin, to the extent he's able to discuss this, is, well, so Article 17A says that it will be in exceptional cases it'll be a five judge bench. The obvious example is when a Court of Appeal judgment is sought to be overturned But would there be any other circumstances which may be classified as exceptional, for example, if they relate to jurisdictional or constitutional powers of the DIFC courts?
Alex, thank you very much indeed for that. Chief Justice, is there anything you'd like to contribute at this point on certainly. Enforcement and, of course, the court constitution?
I'll just take up Alex's question. I can't presently envisage anything that jumps readily to mind, Alex, but I wouldn't rule it out. So that, in other words, if there was a critically important issue relating to jurisdiction or something of that kind that we wanted to put beyond doubt, and we thought that the integrity of the judgment would be assisted by sitting 5 judges, and we might consider it. But to give you some context, there was a provision equivalent to this in the jurisdiction in which I served as Chief Justice of Western Australia for 12 years. I never used it during that 12 years. My predecessor, who served for 17 years, I think used it once. So it will only be accepted. The introduction of exceptional circumstances was designed to allay fears that we might be moving from a standard 3-member panel to a 5-member panel. That is not the intention. There is no intention to do that. Just briefly on enforcement, experience suggests that if you want enforcement in other emirates of the UAE, going via Dubai is quicker and more effective. So if you want to enforce in Abu Dhabi, it's better to go via Dubai. Enforcement in England, one of my judgments has been enforced in England and Wales. So enforcement in England is now the question. And the other thing is there is a policy proposal that's under active consideration for the creation of a new entire Dubai Enforcement Authority, which would be an authority that would be overseen by a board which would have members, representatives of all the courts of Dubai, and it would be populated by judges from all the courts of Dubai, and it would enforce judgments of all the courts of Dubai without differentiation or distinction between those courts. So if that policy proposal emerges, then reference to the conduit jurisdiction will become superfluous because there will be one authority enforcing all the judgments of all the courts of Dubai. So watch this space. But thanks, Alex. That was a very useful overview.
Judge, thank you very much. And a fascinating development of the future on that unitary authority. Given the time of... Excuse me. We will be faithful to our self-imposed ordinance to finish on time. Thank you, Chief Justice. Thank you to the others. One question only, Chief Justice, in the time that remains. You're given powers under Article 10b(3) to, and I'm going to use the words, quote the words, to propose draft laws and regulations relating to the DIFC court's affairs and matters which fall within their jurisdiction. And I know that amongst the panel, we were interested, if you felt able, as to where the scope, really, of the phrase affairs and matters, and whether this might be administrative or might be more substantive.
No, I view it as substantive in the same way as when I was the head of a jurisdiction in Australia. I considered that it fell within my role to make recommendations to government for law reform based on the experience of the courts, because the courts are uniquely placed to identify issues that arise and to make recommendations to government. Of course, it's entirely up to government whether or not they accept those recommendations. But, for example, one of the projects that we presently have underway is a substantial review of the DIFC arbitration law, taking into account the significant reforms that have been implemented in arbitration law in the UK. But I think it's entirely appropriate for the court to initiate considerations of that kind, because we, after all, are responsible for the enforcement of the arbitration law of the DIFC. And if we think it needs modifying, it's entirely appropriate for us to bring that forward. The law refers to the Chief Justice, but I must say I've always taken the view that the Chief Justice is first among equals. So any proposal that would emerge from the court, by which I mean with the consensus support of all the judges of the court. That's how it would work.
But thank you very much indeed. Well, that concludes our webinar. There is one question in the inbox, which I'll deal with by email, given the time available. Thank you very much indeed to all of you who attended. I think one of the best endorsements of any webinar is the attrition rate, and there hasn't been any attrition rate. We started in the same way as we finished. So thank you very much to everybody, both here and of course in the UAE, and I know from our list elsewhere. We've appreciated the thoughts and comments of the Chief Justice, and we look forward to seeing you all in Dubai at the first reasonable opportunity. Thank you very much indeed.
Thank you, everybody.
Thank you.